This is part 35. By this time, as we have dealt with the provisions right from section 299 up to section 377 of the Indian Penal Code, which are the offences affecting the human body, and then right from section 378 up to section 462, offences against the property. Now, as I had told you in the past, the time for me to start with a chapter right from section 76 up to section 106 of the Indian Penal Code, and the heading of the chapter number is 4, and the heading of the chapter is general exceptions. Now, what are these general exceptions? By general exceptions, we mean these are general defenses. Now, if you remember, the first chapter of the Indian Penal Code with which we deals with the application of the Indian Penal Code, namely intra-territorial and extra-territorial operation of the Indian Penal Code, right from section 1 up to section 5. From section 6 up to section 52A are the sections where the chapter 2 deals with general explanations. And now, here onwards also, in the past I had reference to that chapter. We have not dealt with that chapter separately or independently or in isolation. But as and when it was required for us to know a meaning of a particular term, and if that term is not defined by a particular section with which we are dealing, we always have reference back to the general explanations with which we are dealt, and then we will continue dealing with the same as long as we continue dealing with the provisions of the Indian Penal Code. Right from section 53 up to section 75 of the chapter, which is on punishment, where we dealt with two aspects. We had taken into consideration what are different theories of punishment, and secondly, along with the theories of the punishment, we have taken into consideration different kinds of punishment. Now, yet no section of the Indian Penal Code has defined an act which amounts to an offence, but then we come across a chapter, namely general exception, right from section 76 up to 106. What is the reason? By general exceptions, we mean these are general defenses. And then, in short, I can put it, these are the exceptions to every section of the Indian Penal Code which defines an act which amounts to an offence. And to illustrate it, if it happens, Mr. A is on the road, all of a sudden he is attacked by 4 or 5 persons. Mr. A is that much strong, stout and sturdy, as a result of which he repels the attack, which results into death of all the persons who attacked him. Now, this act results into killing of human being by human being. If at all the matter is taken before the court of law, Mr. A is arrested on the accusation that he committed offence of murder by killing 4 or 5 persons. In a court of law, Mr. A by all means can say, yes, Your Honor, my act has resulted into death of these all persons who attacked me, no doubt about it. But I am not liable because my case falls under exception. And which is the exception? He will say, Your Honor, my case falls under section 96 of the Indian Penal Code, which says nothing is an offence which is done in the exercise of the right of private defence. So, section 96, if at all he was charged as per section 302, because he has committed the offence as defined by section 300, this is section 96 is an exception to section 300 of the Indian Penal Code. Not only this, as when we shall be dealing with due course of our with this chapter, you will come to know that there are many exceptions with which we shall be dealing. But then what are these exceptions? These, whenever you want to read a particular section, whenever you want to read a particular offence or section which defines an offence, this section or offence is subject to exceptions right from section 76 up to 106 of the Indian Penal Code. In other words, if the case falls under any one of these exceptions, every section, almost every section starts with the verdict, nothing is an offense. If a child whose age is 4 throws stone into direction of somebody which results into death of that person, what is the liability of the child? If the matter goes to the court of law, there can be argument on behalf of the child that, well, I have done this act, no doubt about it. But then read section 82, which says nothing is an offense which is done by a child who is under 7 years of age. In other words, section 82 is an exception to section 300 of the Indian Penal Code. I mean, barring few exceptions like section 94, which deals with compulsion or threat as a defense, every section starts with what? Nothing is an offense. What does it mean? It is not an offense. For why it is not an offense? Because it falls under any one of the exceptions where there may be absence of mens rea, that is one thing, or there may be incapacity on the part of an individual to do an act, or the person, for example, if he was bound by law and if there is a mistake on his part, then if he has acted in good faith, the question of liability doesn't arise. And hence, this is the important. Legislature, instead of repeating all the exception after every section of the Indian Penal Code which defines an act which amounts to an offense, in order to overcome this situation, not to repeat it every now and then, first of all, legislature thought of having this chapter, namely general exceptions, right from section 76 up to 106 of the Indian Penal Code, and then I mean you start right from section 107 up to 120, which deals with abatement. Section 128 defines the offense of what is known as criminal conspiracy. Right from section 121 up to section 130 are the sections which deal with offenses against the state. And then we had introduction in the past, no doubt about it. But this is the importance of general exception and general defenses. Now, as a student learning criminal law, you will understand one thing, that when a matter goes to the court of law, there are two parties, namely one is an accused person, and this is offense is always an act which affects the society at large, and hence the other party, it is responsibility of the state to maintain law, peace and order in the society, and one party is always a state. So now the burden is always on the prosecution. When the matter goes to the court of law, A is arrested and is taken before the court of law, and the case is that he is liable for the offense of murder. It's not for the provisions of
the Indian Evidence Act for him to prove that he is an innocent person. There is a presumption. Court will take it for granted that he is an innocent person and his guilt is required to be proved beyond reasonable doubt by the prosecution, taking into consideration the nature of the evidence, which may be direct evidence, which may be circumstantial evidence, what is known as indirect evidence, that is required to be done by the prosecution. And now it is not necessary for him to prove anything in a court of law when you go by the provisions of the Indian Evidence Act, right from section 101 up to section 114A of the Indian Evidence Act, to which, I mean, if you remember, we had reference to some of the sections during course of our lecture, deals with what do you mean by burden of proof. And then out of this section, if you read section 105, it says, as far as the Indian Evidence Act is concerned, it says burden of proving that case of accused comes within exceptions, and it says when a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any one of the general exceptions in the Indian Penal Code, or within any special exception or proviso contained in any other part of the same code, or in any law defining the offence, is upon him, and the court shall presume the absence of such circumstances. So now in the illustration, when A was attacked by 5 persons and he, in the exercise of the right of private defense, he killed all the 5 persons, I mean, it will be presumed by the absence, though there were no such circumstances, and then that will be presumed by the court of law. Court will take it for granted that he has committed the offense of murder, and then it is for whom? It is for the accused person. So this is the time where accused person has to prove that his case falls under any one of the exceptions right from section 76 up to 106 of the Indian Penal Code. And if he leads evidence, when there is evidence on behalf of the defense, and if it is possible for him to prove that his case falls under one of the exceptions, then naturally the result would be he shall not be liable for various reasons as per his case falls under any one of the exceptions with which we shall be dealing during course of our lecture. So this is the importance of section 105 of the Indian Evidence Act. Legislature, we have a system of administration of justice in which accused person is presumed to be an innocent, which is based on the principle, let 100 persons who have committed offence go unpunished, but one innocent person should not be convicted by the court of law, and hence guilt of the accused person is required to be proved beyond reasonable doubt. Now this is the time when you deal with the trial, when there is evidence on behalf of the prosecution, there is evidence on behalf of the defense. As far as criminal procedure code is concerned, which deals with various trials, you will come to know at the time when a recording of the evidence and arguments are advanced by maybe on behalf of the prosecution and defense, and now the court wants to deliver a judgment, and at the time when to deliver a judgment with a verdict which may be of conviction or acquittal, the state of the mind is to be or not to be. For example, court goes through, tries to scrutinize the evidence and comes to the conclusion, yes, I think he has committed an offence. After 5 minutes the court thinks, I don't think he has committed an offence. After 5 minutes again court thinks, I think he has committed an offence. After again 5 minutes the court comes to the conclusion, I don't think he has committed an offence. What is the state of the mind of the judge? To be or not to be? In that case, judge doesn't say that he has not committed an offence, but the judge says, I am not convinced of the fact that he has committed an offence, and hence, under such circumstances, when there is doubt in the mind of the judge, a benefit of doubt is required to be given to an accused person, and the order is that of an acquittal. Because trial always results into convicting a person or acquitting a person, so this trial will always result in such a situation. Benefit of doubt is required to be given to an accused person, and hence if that is the state of the mind, judge doesn't come to the conclusion and say, well, I don't say that he has not committed an offence, but I say his guilt is not proved beyond reasonable doubt. A guilt is required. If there is doubt in the mind of the judge, a benefit of doubt is required to be given to an accused person, is the principle of the criminal law with which we are dealing. And hence now this is the time where the accused person admits, yes, that well, I have done, this is the act which is this is the result of my act, but I am not liable because my case falls under any one of the exceptions right from section 76 up to 106 of the Indian Penal Code. So this is, as in case of there are various defenses with which you dealt. One defense that can be raised on the part of an accused person is that accused person can say, well, I will total denied. I do not know anything, don't ask me anything, and I don't want to say anything. Need not. The court, in day-to-day life, silence amounts to consent. Yes, that when you, don't reply to the question which is asked to you, it is taken for granted that you have done that particular act. But that is not applicable as far as the Indian Evidence Act is concerned or the criminal law is concerned. Certainly not. So that is one thing. Second defense that can be raised on the part of an individual is that he can try, he can as he can say, well, the case of the prosecution is that the murder has taken place at such and such place. But then he can say, well, as per section 11 of the Indian Evidence Act, when facts not otherwise relevant become relevant, and it says facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact, or if by themselves or in connection with other fact they make the existence or non-existence of any fact in ensure or a relevant fact highly probable or improbable. So here if the person, for example, and if you read the illustrations which are given, it says the question is whether A committed a crime at Calcutta on a certain day. The fact that on that day
A was at Lahore is relevant. So this is what is known. You try to prove, the accused person will try to prove that he was not at all present at the scene of the offense, what is known as defense of alibi. Defense of alibi, where alibi, where he will try to prove that I was not present at the scene of the offense, and hence the question of liability doesn't arise. A plea of alibi must be proved with absolute certainty so as to completely exclude the possibility of the presence of the person concerned at the place of occurrence. It is well settled that a plea of alibi has got to be proved to the satisfaction of the court, and hence if that is one defense which is available. And the next defense, or the last defense as far as criminal trial is concerned, which can be raised on the part of an accused person, is he can admit the act that is done, but he will say I am not liable because my case falls under any one of the exceptions, right from section 76 up to 106 of the Indian Penal Code. Now, for the sake of convenience, what are we going to do? We are going to club the sections so that it becomes very easy for us to deal with the sections. I mean, we will club the sections together so the understanding of the particular section becomes very clear. As we will start, we will take into consideration what do you mean by mistake of factual defense, where we shall be dealing with two sections, namely section 76 and section 79. Section 76 deals with the cases where the person is bound by law, whereas section 79 deals with the cases where the person is justified by law. We will work out together both the sections, section 76 and section 79. Then we will deal with two sections, namely section 77 and section 78. Section 77 deals with the cases when act of a judge when acting judicially, and section 78 act done pursuant to the judgment or order of the court. So judge is protected as far as section 77 is concerned, and those who act as per the direction which is given by the judge are protected as far as section 78 of the Indian Penal Code is concerned, with which we shall be dealing. Then we will take into consideration only one section, namely section 80 of the Indian Penal Code, which deals with what do we mean by accident as a defense. So that is, I mean, one section independently with which we shall be dealing as far as section 80 of the Indian Penal Code is concerned. Somebody is driving a vehicle at a speed, and all of a sudden somebody wanted to cross the road and he had dashed against the person. So instead of his vehicle dashing against a person has dashed against his vehicle, which has resulted to death of the person. What is the liability of the person who was driving the vehicle is the question for our consideration. And there, if his case falls under section 80 of the Indian Penal Code, with which we shall be dealing, as to try to understand what do you mean by accident as a defense. With this, we shall be dealing with the section when there is absence of criminal intention, and first section with which we shall be dealing is section 81, which says act likely to cause harm but done without criminal intent and to prevent other harm. So that is section 81 with which we shall be dealing. During course of our lecture, when we shall be dealing with section 81, we shall also try to understand what do you mean by, this is not the concept which is mentioned anywhere in the Indian Penal Code, but necessity as a defense. And then along with section 81, we will try to understand section 94 of the Indian Penal Code, which deals with what do you mean by compulsion or threat as a defense. Along with this, we will also deal with section 92 of the Indian Penal Code, where the act done in good faith for benefit of a person without consent of the person, and then section 93 of the Indian Penal Code, which deals with what do you mean by communication made in good faith. So this is the group of the section with which we shall be dealing. Section 81 to be read with section 94, then we will take into consideration section 92 and section 93 of the Indian Penal Code. Then we will start dealing with a group of sections where there is incapacity to commit an offense. And in order to understand incapacity to commit an offense, the first group of section with which we shall be dealing, where we will try to understand what do you mean by act of a child as a defense. And in order to understand act of a child as a defense, we shall be dealing with One, section 82 of the Indian Penal Code, and the second section to along with this, with which we shall be dealing, is section 83 of the Indian Penal Code. So section 82 and section 83 are the sections which deal with act of a child as a defense. With this, now we will proceed to section 84 of the Indian Penal Code, which deals with what do we mean by insanity as a defense. Person, if the act is done by a person who is a person of unsound mind, and hence now what do you mean by insanity as a defense, with which we shall be dealing when we will take into consideration section 84 of the Indian Penal Code. With this, now we will proceed to next two sections. Section 85 and 86 are the section with which we shall be dealing, where the act is done by a person who was intoxicated. And in order to understand this, as we shall be dealing with this, the section, we will definitely take into consideration what do you mean by voluntary intoxication, what do you mean by involuntary intoxication, and rest of the details with which we will continue when we take into consideration section 85 to be read with section 86 of the Indian Penal Code. With this, now, if the act is done without, when we talk about act is done with the consent, we shall be dealing with, first of all, we will try to understand what do you mean by consent as it is defined by section 90, which you have dealt in the past. But then we will take into consideration section 89. We will also take into consideration section 88 and section 87 of the Indian Penal Code. So these are the sections, where act is done with the consent of the person. As I have told you, we shall be dealing with section 87. Section 87 deals with the cases where act not intended and not known to be likely to cause death or grievous hurt done by consent. 2. Section 88, act not intended to cause death done by consent in good faith for the person's benefit. And section 89, act done in good faith for benefit of child or innocent person by or by consent of the guardian, for which we will refer to section 89 of the Indian Penal Code. With this, now we intend to start with one section, and that is section 95 of the Indian Penal Code, which is based on the maxim de minimis non curat lex. So that with which we shall be dealing, where we will try to understand as to act, what is the if the nature of the act is such that it causes slight harm, act causing slight harm is not an offence, not made punishable by the provisions of the Indian Penal Code, with which we shall be dealing as far as section 95 of the Indian Penal Code is concerned. And then section 96, from section 96, as far as this chapter is concerned, the most bulky part of it, namely to correlate many sections, we will start discussing right from section 96 up to 106 of the Indian Penal Code, where we shall try to understand as to what do you mean by a right of private defense, right from section 96 up to 106 of the Indian Penal Code. Now, the order may be, it's not that we have to start right from section 76 itself, certainly not. So as and when, but what we will do, we will cover all the general exceptions by clubbing those in sections in the manner for the purpose of understanding the same, right from section 76 up to 106. Now, next time, in the next part when we will meet, we will start discussing right from section, first of all, as far as this chapter is concerned, we will start understanding right from section 96 up to 106 of the Indian Penal Code, where we will try to understand, first of all, what is this right of private defense. Right of private defense, right from section 96 up to 106, with which we will have a discussion, or we will continue with this as far as next part is concerned.